Hey, everybody, and welcome to another episode of the Canadian Immigration Pros podcast. I'm your host, Josh Schachnow, Canadian immigration lawyer and CEO over here at Visto.ai. I'm happy to be joined by Adrienne Smith today. Adrienne, thank you very much for coming on the show. We appreciate it.
Thank you. Thanks for having me, Josh.
Absolutely. I'm excited to jump into a few topics we haven't really covered in depth yet on the Canadian Immigration Pros podcast. We're going to talk a little bit about federal court applications. What does that mean? When does it apply? We'll talk about reconsideration requests, which I think have probably become more popular and maybe required than ever before, and common reasons for refusal for visitor visas, which, very important. They're the highest volume application per year. And so especially those maybe who have struggled with it in the past, or maybe some immigration professionals looking for advice on how to overcome them. Before we jump in, can you tell everybody a little bit more about yourself?
Yeah, so I've been a lawyer in private practice for 10 years and practice exclusively in immigration and refugee law. And I have a really wide variety of files that I work on in my practice. I kind of specialize in doing litigation before the IRB and the federal court, but also, to mix it up and make sure I'm not in court every day, have some solicitor-based files like visitor visas and student visas and express entry and PR applications and all the rest. But I think my real passion is, fixing complicated files that have gone awry, maybe from a previous representative or, have something an issue on a file that's really complex and nobody else wants to take it on. And that's kind of where I built my practice, is on unwinnable cases and winning them. And they're intellectually really stimulating and obviously, really fulfilling for the client when a lot of them have lost a lot of hope, and to get that positive decision is just an amazing feeling.
I bet. And can we start maybe from the very beginning, both for people who maybe don't know too much about Canadian immigration, or the, solicitor peasants like myself who've never been in court on the immigration side? Could you tell us, like, broadly speaking, what is immigration litigation? When does it apply? What are these types of files like?
Yeah, that's a great question. So, when we talk about litigation, we're basically talking about either, bringing an application to a court or a tribunal, or defending an application in a court or a tribunal. So, in the immigration context, basically, when you get an immigration decision and you want to appeal that decision, then often in the immigration world, you don't get a full appeal. You get a review of a decision by a judge called judicial review. So the federal court is kind of the most common place that we go to challenge decisions. If we disagree with a decision, or if the officer's made an error or a mistake in reviewing the application, often our only remedy is to go to the federal court and to ask the judge to review the case.
Right. And well, I mean, for some of us, the only other option is just apply again, right? But as we'll kind of talk about, there may be reasons, to pick one option or the other. I bet you a lot of aspiring immigrants, maybe ones that are listening, don't even
Yeah.
know what the potential appeal process is, or if we can even really call it an appeal, right? Because like you said, what happens is you go to court and you kind of argue that your application should be reconsidered, right? So, I mean, correct me if I'm wrong, but if you win in court, it's not like your application is approved, right? You're arguing that it should be sent back to be processed again, correct?
That's exactly right. And, that's obviously very confusing for individual applicant or an immigrant who's trying to come to Canada and they've gotten a refusal, and you go to court and you win, and they're thinking, okay, great, now my application is approved. And you have to tell them, well, no, actually it's going back to the exact same, government that made the decision before. It's just going to a different person of that government. So you're
Right.
right. It's a very kind of confusing concept, but it's the way that the federal court judicial review process is set up.
Right. And can you talk a little bit, Adrienne, about, number one, are there specific types of applications that you find are getting litigated more than others? For example, do you get more TRVs to litigate versus PR or work permit or whatever? And then number two, of those cases that you win, would you say it's like a greater than 50% get approved on the second time? Or I'd love to understand what those numbers look like, partially because I'm curious, and partially maybe for listeners who are like, okay, well, maybe I apply I apply and it gets rejected. What's the better option? Should I just submit a new application, or is it worth it to try in JR, where even if I win the court case, it just goes back to be processed, and then what's the chance that that gets approved on the reprocessing? I'm throwing a lot at you at once here. Maybe we can break it into kind of two parts. But yeah, like what are the types of files that you find are getting litigated a lot? And then what do you see in terms of results for those files that go back for reprocessing?
Yeah, so both really good questions. I think for all of us in the immigration space right now, what we're seeing is a lot of refusals on temporary resident applications. So things like a visitor visa or, a student permit. So, the temporary resident rate of refusal, I don't have statistics, but in my own practice, I find it's gone up. I find, I've been filing really strong visitor visa applications only to get a refusal within a few weeks. And often finding that a lot of what's said in the decision actually doesn't even apply to my client's case. And that, there's kind of these cans for refusing the application that don't really consider any of the evidence that I've submitted. So, in my practice, and I think with speaking to a lot of other immigration practitioners, there's just been a really high rate of refusal for visitor visas and student visas. And then, when we're talking about what happens if you win at the federal court and, should you reapply or should you, do the federal court application? If you're successful at the federal court and the case is actually reopened and goes back to an immigration decision maker for what's called redetermination, the chance of success, in my experience, is actually very high. And the reason for that is because the new decision maker has instructions from the Department of Justice lawyer that represented the government in the litigation, and they have identified what the error is and what the mistake is that was made. So there's been communication between the Department of Justice and the IRCC saying, by the way, don't make this mistake again. You made this mistake once, don't make it again. So I find, at least in my experience, when I go back for redetermination, in all of my cases, I've actually had a successful decision if we get it reopened. So, a huge benefit to going to the federal court, I think.
Right. So maybe no guarantees, but you're saying very, very high chance of success if you JR and you win the JR.
You JR, you win the JR, and obviously you're supplementing your new application. You have the benefit of knowing exactly why the application was refused. So when you're going back on redetermination, you're also providing an even better application.
Right. So what do you advise? Let's say I'm a client and I work with you and we submit a TRV and it gets rejected for whatever reason. We'll talk about reasons maybe later on in the episode. It gets rejected and you think it's like not that great of a reason. How do you explain that to the client, and how do you kind of pitch, or maybe pitch isn't the right word. How do you suggest, or how do you outline the two different options, right? Like submit a new application versus JR. What's the difference? What's the overlap? How do you advise clients?
Yeah, that's, again, a really good question. I think the number one thing that I always do is get the actual written reasons for the refusal. So as you know, when we file these applications, we're going to get a decision letter that checks off a bunch of boxes that says, okay, the purpose of your visit doesn't accord with what you said in your application, or, there's financial sufficiency issues, whatever it is. You get a decision letter that checks off these reasons, but you don't actually get the detailed written reasons from the decision maker unless you ask for them. So either by filing a federal court application or by doing an ATIP and asking for those written reasons. So when I'm advising a client, I'm looking at those reasons and then I'm telling them, okay, the officer here says that you only submitted 1 month of bank statements. And, remember when I asked you to submit 3 months of bank statements, but you said you didn't have them. The officer has pointed this out as evidence that they wanted to see. So in a situation like that, I'm very likely going to tell a client, you know what, let's reapply. Give me the bank statements. Let's address this reason for the refusal. Or I may rate the reasons and the officer says, applicant doesn't have enough funds to support a 2-week trip to Canada. But I've provided, upwards of $20,000 to $30,000 in savings for that trip. So in that circumstance, I can see right away that the officer hasn't looked at my evidence. They haven't considered any of the financial documentation that I provided with my application. So in circumstances like that, I'm very likely going to advise a client, I think we need to go to the federal court to quash this decision. Even if you don't want to, continue with the application, as an applicant, you never want a refusal on your file. If you're going to apply in the future, then it's good to get that, that decision quashed.
Right. I mean, I even think about like in other temporary, I think as well, and PR applications, questions like, have you ever been, refused, denied, et cetera, et cetera. So like you said, could kind of hold you back, unfortunately, down the road, even if it's a bad decision, right? Like the processing agent makes a bad decision. Okay, so let's say the client decides they want to JR it. Probably could be an episode in and of itself, but could you give us like a 1 minute, maybe 2 minute description of like what is the JR process from start to finish? Like what are you filing? Are we going to court step one? Like what's that kind of look like?
Yeah. So in 1 minute, step one is we file what's called an initiating document. So we file a document that says, this is the decision that's made. We disagree with the decision. We're going to start a judicial review application. We file that with the court. The court then asks the IRCC for a certified copy of the reasons. So then the IRCC will send the court a copy of their written reasons, and then they're going to send that to us. And then 30 days later, we have to decide if we want to continue with the application. So that's when we're filing what's called an application record, which is basically your detailed legal arguments about the specific errors that an officer made in their decision. You're pointing to evidence, you're pointing to case law. So you're trying to show that there's some sort of merit to your application. Then it's going to the Department of Justice to respond in writing. And then we get a reply 10 days later. Then all of those written materials go to a federal court judge. And usually about 6 months or so later, then a federal court judge is making a decision about if they think that there's merit. So there's a bit of a gatekeeper function at the federal court. You don't automatically get a hearing. You have to prove you have some merit to your case. Then if you prove that, then about 6 months later, a judge will book a hearing date for 3 months after that. So, the whole process, and this is a lot for clients, right? Like you're trying to come to visit your brother in Canada for 2 weeks. So like, why would you go through such a long process? But what I'm seeing with a lot of these decisions that are being made is the error is so clear that the government is actually settling a lot of these cases, sometimes weeks within filing that initial document. So in all of my cases, I've actually never had to wait the 6 months because everything has settled before then.
Every single one.
Every single one up to date. Let's not start tomorrow.
I don't want to jinx any future clients. So it sounds like, let's say it does go the whole, the entire gambit. You're looking at like a 9 to 10 month process to get your quote unquote day in court. And then what happens? Let's say you do get to court. Is a decision made that day or does it come later? and then not to scare people because, as you said, it seems like most of them don't go to court. So on average, it's not like an 8 to 10 month process, right? Like you said, it could be a few weeks. So, okay, two questions here because my mind, like I'm loving this stuff. This is even really good learning for me. Is so you can settle. So I'm assuming what happens is maybe the arguments go in or the GCMS notes come back, and are they called? They're not a prosecutor, right? That sounds kind of harsh for like an immigration case. The
Yeah,
the
maybe.
lawyer on behalf of the government.
Yeah, you can call them the crown, either one.
Right. So let's say the Crown takes a look at the GCMS notes and they're like, "Oh, this was a pretty stupid mistake by the processing agent." So what does settling look like? They'll come back to you and say, "Hey, Adrienne, yeah, clearly this was wrong. You'll get your reconsideration," or how does that work?
Exactly. So, we'll get a message, usually a written letter from the Department of Justice saying, we agree that there's an error that was made. We're going to quash that initial decision. We're going to reopen the visitor visa application, and we're going to send it back to the visa office for processing.
Okay, so this is really good info because when I kind of started thinking about and learning about JRs, I was like, well, this kind of sounds like a crappy option. You you know, must have to spend extra money, right, to hire a lawyer to do all this stuff for you, and it's going to be months and months and court fees and blah, blah, blah. But hearing this is pretty nice because what you're saying is, could be within a month or two, assuming it is an application that is worth JRing, as you kind of alluded to earlier, there's a good chance within a month or two you might get your quote unquote win being it's going back for reconsideration or redetermination, as you said. So it actually sounds like it could be quite a good option, especially if applying from a country with like a super long processing time, right? Where submitting a fresh application could take much longer to process. Like, what are your thoughts on there when kind of weighing the two?
Yeah, I mean, I think like it is a lot more accessible option than I think what people realize. And I think, as you mentioned, the strength of it is really just going to come down to whether that initial application was prepared properly and whether, all of the potential reasons for refusal were addressed in that initial application. So, it is just such a great option if the application itself is strong and if the error from the officer is really clear. Now, I would say like most people do reapply and they think, okay, I'll just like resubmit a new application. But I just find the main obstacle or barrier to that option is then when you're going back for a fresh application, then you're dealing with the previous refusal. So you're dealing with an application that's already got a red flag on it. Like when we're talking about
Right.
Chinook flagging applications going into either a, more complex or a less complex stream, the more complex are going to be applications with previous refusals. So, unless there's a really specific, reason why the application was refused, and then you're providing that exact piece of evidence that the officer flagged in the last application, and you're saying, I understand why the application was refused. I should have provided this. Here it is. I have a good application for all these reasons. If you're just kind of throwing another application for a second kick at the can, I think it's really dangerous to rack up multiple refusals when you're trying to get to Canada.
Right. Yeah, I mean, listen, this is great information, and part of the reason why I'm kind of reading between the lines too to what you're saying, which is it's so important to submit a great first application, probably now more than ever before, because like you're saying, number one, refusal rates seem to be higher, and maybe there's some data to support that. I don't know off the top of my head, but it's something we could look up on the IRCC website. And secondly, if that first application gets refused, you're probably going to have a higher chance of JRing successfully, the higher the quality that first application was, because you can point out the flaws of the processing agent, if there are any, much better. So, I mean, listen, we This is the Canadian Immigration Pros podcast. We only bring on regulated immigration lawyers and consultants by design, right? So, take it from us. Another reason, another chip in the stack to, work with reliable professionals that are going to help you prep the best application that first time. Not just to give you the best chance at getting that first approval, but if you don't get an approval, your chances of JRing successfully, reapplying, et cetera, are probably that much higher. Now, Adrienne, I want to ask you about maybe what's considered a third option, quote unquote, but I'd like to hear your thoughts on reconsideration requests. Also something that maybe a lot of aspiring immigrants don't even know exist, right? Kind of like this, kind of called appeal. It's not really an appeal, right? More the judicial review that we talked about. But what is a reconsideration request, and when might you recommend or do that for your clients?
Yeah, so reconsideration requests are a written request that you make to the exact same person who refused your application, basically saying, can you please make a different decision? So this is different than the federal court, which if you win, it goes back to a different decision maker. In reconsideration, you're basically going to the same officer and you're saying, listen, there was an error that was made, or, for whatever X, Y, and Z reason, I'd like you to reconsider your decision. And so this is a written request just sent directly to the IRCC. And there's no real, I would say, formal process on how you do them and what you put in them. Now, what we do know about reconsideration requests is that there's a ton of misinformation about when they're effective. I come up against kind of a lot of immigration consultants and immigration lawyers that say, as soon as I get a refusal, I just submit a reconsideration request. And the conversation I have with them is always, but if you don't know the reasons for the initial refusal, then what are you putting in that reconsideration request? Just please make a different decision. I think it gets clients' hopes up. I think it's a waste of the IRCC's time. And I think in so many cases, they're just not effective. It's not an effective solution. So when are they an effective solution? It's really intended in the case law. We have case law from the Federal Court of Appeal that talks exactly about this issue of reconsideration for an administrative decision maker. And what the Federal Court of Appeal basically says is if there's some kind of breach of fairness in the processing of the application, that's a reason to go back to the same decision maker. So the most common scenario that I use this sort of request in is, for example, if you've asked for an extension of time from IRCC to submit additional documents, and they don't look at the extension of time request and they refuse the application. So that could be, you could argue that's a breach of fairness. Or if, for example, the IRCC, sends you a request for a payment receipt, you need to pay your IRCC government processing fees. But in fact, you've already paid them and you already sent them the receipt and then they refuse it. Again, that's a breach of fairness, a reason to go back to the IRCC. And then the last most common scenario that I use it in is if there's some sort of incompetence or negligence in the first representative who prepared the application, then the court has repeatedly said that, there is a breach of fairness when applicants aren't represented by competent counsel. So in circumstances like that, I may be filing, some sort of written request for, professional body to look at negligence or incompetence from a representative. And then I'm asking the IRCC at the same time to reopen the application and providing new evidence. So it's these kind of really limited circumstances that I'm asking for reconsideration.
Right. And I think maybe part of it stems from the refusal letters being so useless, but I like your initial point of, hey, first of all, let's probably get the GCMS notes and see the real reason or the core of the problem to why it was refused, so that if we are going to use up, effectively IRCC resources, right? Because if everybody just did this just to do it, kind of like you said, I mean, they've already been backlogged for 4 years, right? So they're not exactly sitting pretty with extra people hanging out with a lot of free time. So I like that approach. And then, so are you saying that there's a difference where, based on the error, whether it relates to fairness or not, you might do a reconsideration as opposed to a JR? Like, is there ever a situation where you would not do a reconsideration request and go right to a JR? And if so, why? Like, is it not worth the reconsideration request just to throw it out there and see what happens?
Yeah, I mean, I think that's a really good point. And I think what you're looking at is, and I guess what we could talk about the risk of if you take the reconsideration option, because you're kind of saying, like, why not just do a reconsideration whenever there's a breach of fairness? But the risk of going back for reconsideration is that the officer can actually bolster or supplement the reasons. So they
Hmm,
can kind of relook at their own decision and say, okay, this person obviously wants to challenge their decision. They may be going into federal court. Let me add a little bit more context about why I'm refusing their application. So if that happens and then the officer reasonably justifies refusing the application, that's going to hurt your chances a lot at the federal court. So, it's so
interesting.
case specific where you're making that kind of risk analysis about whether to go back on reconsideration or you're going right to the federal court.
Right. So to kind of summarize, and maybe especially for practitioners out there that don't or can't do JRs, the point that I'm taking in my head is, hey, if this is like a clear win as a JR, maybe it's not worth the reconsideration. Like, what's a good case to file a reconsideration request? And as far as I know, is it as simple as filling out the web form? Like, if we go to the actual steps, is that what it is? Like writing text in the web form, and then obviously you get the option to attach documents?
That's a really good point. So, what's really interesting about reconsideration requests is you can actually even make them over the phone to an IRCC call center agent.
Huh.
So,
If you can get one on the
one,
line, right?
if you
Obviously.
get one on the line, if you have, 3 free hours in the morning to call IRCC and get automatically disconnected multiple times, then absolutely. So you can call the IRCC call center. You can ask for reconsideration. You can submit a written request through the web form. For me, my practice with reconsideration is to do full submissions. So I'm setting out the case law that shows the officer what their legal authority is to take this step. And then I'm very often doing an affidavit from the applicant explaining the context and the circumstances. So my reconsideration requests are usually a little bit more involved. But at the same time, if it's simply that, the IRCC, ignored an extension of time request that our office made and we got proof of that request, maybe I'm just doing a straightforward cover letter and attaching a copy of our request.
Got it. And what about timelines? From what I understand, and correct me if I haven't practiced in years, right? Let me just throw this out there. That's why, I'm heavily relying on Adrienne to correct all my,
Wow.
erroneous statements, if
Well,
any.
you can't tell. It seems like
Well, I
you're
stay up to date, right? And I obviously, especially for those who follow us on LinkedIn and our email list, I certainly stay up to date, but I do
no
not
kidding.
go through the day to day, right? Of like, on the ground practicing all that kind of stuff. So when it comes to timelines, I guess my two questions are, number one, okay, you file it. What happens? Isn't there the case where they just don't, like they either approve it or they just don't respond? And then if that's the case, or whatever the case may be, I think there's a time limit in which you have to JR, right? So is another consideration like, hey, if we're going to file a reconsideration request and it takes weeks or months or we never hear back, then our JR timeline might lapse and then we can't even JR?
Exactly. So, like, you sound like an experienced litigator right now. So, that's exactly the sort of thinking that we go through. As you know, with federal court applications, if the decision's made outside of Canada, you have 60 days. So, we file that reconsideration request and then, we wait until day 59. And if we don't get a decision on that reconsideration request, we're filing with the federal court.
Got it. And then Am I correct in the sense that if they quote unquote reject your reconsideration request, they just don't respond? Like, do you get a message back saying, "Hey, we read your thing and we don't care"?
I would say it's about 50-50. Sometimes I get a line just saying, considered and refused. Sometimes I'll
Hmm.
get supplemental reasons about why they're refusing the reconsideration. And sometimes I get nothing. Well, that's the other, part about reconsiderations is it kind of goes into the IRCC black hole and you don't know what you're going to get back.
Right. So what's a good timeline for people to think about in their heads in terms of, hey, if we don't hear back by then, we probably want to start making other plans? Is it a month? Is it 2 months? Is it 2 weeks?
I think, exactly what you said, Josh. I think it's paying attention to your federal court timeline
Mm,
and then basically just making sure that you meet your federal court deadline. If it's an in Canada decision, that's a short timeline. It's 15 days to file with the federal court. If it's overseas, you've got a little bit more time.
got it. Okay, this is great information to keep in mind, I think, not only for aspiring immigrants, but again, maybe there's some other practitioners out there. Maybe it's lawyers who don't do any litigation, or maybe it's consultants who can't do litigation and want to keep these things in mind for their clients. Obviously the good ones out there probably want to think long term and have the best interests in mind. So I think this is really good. The last thing, Adrienne, we wanted to cover was reasons for visitor visa refusals. As you said, anecdotally kind of on the rise. And the other thing that I found from my experience was that it can be kind of subjective, right? Like from my experience when I was practicing, if you're applying for something like a work permit or express entry, it's a little bit more objective, right? Oh, you have the LMIA. Oh, you can show that you're fit to complete the duties of the job. Very high approval rate. Similar with express entry. You're eligible, you have a high enough score, you have the proof of funds, you know what I mean? Visitor visas seem to be the opposite, similar-ish to study permits, where it's a little bit more subjective. I'd love to hear what some of the leading reasons for refusal are, and then maybe we'll start with that, or we can talk about some ways to think about overcoming them from the get-go.
So I like the way that you describe the difference between like a more objective immigration application where there's really specific eligibility criteria. If you have the points and you're going to get an invitation to apply under express entry versus something that's more subjective like a visitor visa application. So I really like how you kind of characterize that. And I think, with a visitor visa application, that's where like advocacy and experience is just so critical. And that's the one thing I love about doing litigation is because when you get to see all the reasons why applications are refused, then when you're actually preparing the initial application, it's almost like your spidey sense is up for all those potential gaps in evidence that you've seen happen in other files or you've read a federal court decision that pointed to this exact gap in evidence. So that's one thing I love about having a solicitor in litigation practice is that you have a different kind of hat on as a litigator. And we do see like in my practice, because I do a lot of federal court work, I see these kind of common reasons that keep coming up for why a visitor visa is refused. And this has just, I find, again, don't have statistics, but I find it's really increased within the last year or so. Some of the things that I'm seeing in my practice and from other immigration practitioners is really commonly just saying that, there's no financial sufficiency. That's always a big one. Basically, what that means is, you don't have the money to show you can pay for your plane ticket and the cost of your trip. But going back to what you said initially, there is no magic number or magic amount of money that you need to provide for a visitor visa application. So it is a subjective assessment. So when we're preparing an application, like what number do we give a client when they're like, okay, how much money do I need to apply for a visitor visa? And it's very case by case. What we do is we look at how long you going for, who you staying with, what's the reason for your visit. So, we're looking at what are the flight costs from your country? What are you planning on doing? How much money are you going to need for that? Are you staying with your immediate family members so accommodation isn't an issue? So, you're kind of doing almost like a personalized assessment about how much money you think the individual needs. Now, there's no maximum, so the maximum, the better. But one thing that I think a lot of people don't know, and I think what I see with a lot of gaps in evidence, is the proof of funds can also come from the Canadian host. So, whoever it is that's inviting the foreign national to come to Canada, like, include the Canadian host's notice of assessment to show they have a good income, you know, provide their 3 to 6 months of bank statements so that, yes, ideally you have all that proof from the applicant themselves, but maybe you also have proof from the Canadian host that shows, well, the foreign national isn't going to pay for anything. I'm actually covering the flight cost, accommodation, and the money they need for their trip. So I find that's kind of one common refusal and one way that we at our office are preparing our applications now, really strong applications with lots of proof of financial sufficiency.
Right. That's great advice. I mean, it almost begs the question, why don't they have a more objective proof of funds requirement, right? The study permit has it, express entry has it. Work permits typically don't need them, right? Because they're kind of exempt. They're, coming to be employed here. But it would be great if they had a similar equation, right, to something like the study permit, where it's like, hey, if your program's this long and you have this many family members, you need to bring X. And similarly, it would be cool if it was, hey, you're coming to Canada for this many weeks, and you're bringing this many family members, or you're staying at a hotel versus you're not staying at a hotel. But anyways, maybe we'll get that one day if we hope and pray and, wait a few years. Any other tips, Adrienne, in terms of specifically visitor visas, maybe study permits as well, if you have much experience there and want to chime in, like one or two other common reasons for refusal, or even just one or two more tips for bolstering those types of applications to give them the best chance of success?
Yeah, absolutely. So, and I also really like your suggestion. I think you probably have some IRCC policymakers that are listening to your podcast and thinking, oh, maybe we should have a checklist for
I hope so.
visiting the applicants. So I love that. I think it's a fantastic idea. So as far as, other kind of tips when you're applying for a student visa or a visitor visa, one other common reason for refusal is obviously the ties that you have to your country of citizenship. So the best possible proof, what I always tell people, and this is hard for a lot of people to hear, is having a spouse or child in your country of citizenship. So that's really going to be your best tie. If you're all applying together, the reality is the chances are just going to be less. And then obviously, the regular things like property ownership, employment letters, everybody kind of knows about that evidence. So I'd like to usually have at least one, if not all three, some property ownership, some immediate, if not very close relatives that are dependent on the applicant, and, some stable employment with a permanent job and a job letter. I
Got
think,
it.
one other common reason for refusal that I'm seeing is the reason why someone's coming to Canada. So often they'll say, okay, the purpose of your visit doesn't match up with a temporary purpose. And I think what's really common to do in visitor visa applications is to create the application around an event, like someone's wedding, someone's birthday, some kind of big community event that's happening. But I actually find that, very often when I talk to my clients, they actually just say, like, I haven't seen my brother in 5 years and I haven't visited his home in Mississauga, and I would love to come and, to see my niece and nephew. And so, often we're creating a visitor visa application around a genuine purpose like that, which may be my niece and nephew are going to be on summer vacation in July and August, and I want to come for this period for 3 weeks. Like, kind of personalizing it to the situation of the Canadian host and the applicant, I find is the best way to show you have a really kind of genuine reason for wanting to come to Canada.
Yeah, those are great tips, especially because, I mean, we think it's still humans reviewing them and making final decisions, right? So like you said, if you kind of personalize it, maybe it's easier for them to, think about it in their head and it makes a little bit more sense and maybe a better chance for approval, at least until all the robots take over. But anyways, that's for another conversation. Adrienne, this has been really great. A lot of great advice, a lot of really insightful information that's even helpful to me and hopefully to other, immigration practitioners that might listen or aspiring immigrants that might be, trying to learn and improve their chances. So we really appreciate you coming on the show. If anybody does want to get in touch or maybe learn more about you or your firm, where do you recommend that they go?
So I post on LinkedIn about immigration issues, immigration decisions, and highlighting some cases that our firm is working on. So finding me on LinkedIn is a great way to connect. And then, my firm is Smith Immigration Law, so finding us online as well is a great option. So I think those are the two best avenues. But Josh, your questions today are just really, I think, also very insightful and really shows your experience in the area of immigration. So thank you.
Yeah, my pleasure, and thank you for taking the time to come on the show. We will have links to the website and to Adrienne's LinkedIn profile in the description below if you're watching on YouTube or if you're listening on your favorite podcast platform. Adrienne, thank you again for coming on the show. We really appreciate it.
Thank you, Josh.